Okay, latest machine to have this class. It's actually very troubling, quite difficult to handle. So we now progress to the private field of international contract. As I've said, there are two perspectives about the scope of this course in subject. For example, Professor Folsom would have a practical eyes to offer a legal assistance and also some more requisite information for the player, particularly the private enterprises and actually who actually engaged in the international trade. And they saw that context of law is pivotal and major a topic should be dealt with is comprehensively, but as coupled with a public law. So they also combine the aspect of a public law, which should be employed to explain and take account of the trade issues. One other concept, the principal advocate in theory and in this discipline, Professor Smith. So a distinct nature between private and public law in theory and ways of operation and its nature to govern the relationships of involved parties in legal terms. So two views. That view also realized within the books authored by two professors, Professor Folsom and Schmidt. Professor Schmidt is an influential figure, as I've said, with an educational background in Germany. So actually must be extensively exposed to the civil law traditions, but his practice in teaching and other international activities was based on London. So coupled with civil laws and common law traditions, and actually principal engineer to steer the organization UNCITRA. So I have uploaded, it was buffet, of course, in this morning. So I just deposited in my email account. By later, would upload the CISG, which is also representative source to found this class, and which deals with the norms in essence to govern the sales of contract in the international market. It is most notable achievement made through the decade. It was encoded in 1984, and I've retrieved it from a website offered by a Paris University. The university has endeavored on the sphere of international trade laws, and now attempted to organize the international concerned people about this area of law. So I will upload later in my personal homepage for your reference. And as I've said, you have some eyes and views to cohere with the nature of this norm. For example, UNIDROIT principles is actually not a law in strict sense and prevailing understanding of laws. So it is a soft law and crafted, negotiated and deliberated and crafted and actually agreed by the group of scholars concerned. As you see in projection, for example, notably the lawyers from the continental tradition in Europe, and also, for example, Dan Stallone, a university draw, many viewpoint was actually instilled by this nature of steering committee and participated by phenomenal scholars. So you can see some of scholars. So who are they? They are just scholars, no authority to codify any binding nature of laws. So it is interesting. So one commentator prank about this tendency, but actually it is very strong in authority and a leading law about this area of law, and it signifies the ways of dealings as verified in restatement in the domestic law of the United States. You can see this norm is secondary in nature, but very influential and cited in weighty force by jurors and many authorities in the United States. That kind of approach was adopted in the international command, typically realized in this document. UNIDROIT is, as I've said, branch organ of the United Nations and one of two organs commissioned with a uniform private laws in the international trade law. The other sister organization, UNCITRA, I've said was led by Professor Smith, and also led to many successes about unification of private. So we view this mainstream as kind of a new Rex Mercatoria, revived and based on the old methods in times. But the difference is obviously larger. It's forms of norms. In new Rex Mercatoria, although its exact nature varies across the law, sub-law. Is notably an internal agreement in strict understanding of international law. So it is treaty and legal process in domestic protocol by each nation. And finally, signed by actually the head of states, mostly in cases. And one other source you may have mind as you recall is from a comment, and text was keenly related with the nature of trade contract, distinct from domestic laws. For example, in the print out reference, many risks involved in the international business transaction. Source to correspond with this risk payment, for example, merchants will say the risk and fear from non-payment. I later know the USHP document, for instance, So you may go forward and backwards through the documents, and as complement with the practical points distributed in that class. For example, you can see the global and regional marketplace. The title of the first printout, and the title you can see some of statistics and the basic introduction about a profile of international trade in this contemporary times. And also you may be founded on laws of international business transactions to understand the prime feature of this area of law, international customary law. Also, you may have subtitle, preventive contracting and the CISG, which discloses some of nature involved in international contracting. And in this point, you also be helped out by referring to model contract over areas of trade. For example, sales trade, a sales contract, an employment contract, or construction contract, and what a Korean commercial arbitration also provides the website about the model contract pertaining to each area of a trade. So coupled with CISG, a source of loan you have to delve onto. One other point would be made about a direct exporting. And many institutions now endorsed by the society, international community of a merchant, should be related with the risks and its evaluation. So what risks are intriguing to correspond with, or to opt out for removal of a potential challenge. The author highlights some point in the context of developing countries. The merchants in developed countries usually fear from some lower profile of a civilized laws and other dictatorship to obligate the property rights and others. So condemnation without compensation is one source of fear, and actually imposing. Purchase a company in the Russian Federation and Germany. How do we compare? So you see the point and scenarios. And also, we may identify linkage and cultural risk. So there are more chances to be confused and misunderstood in negotiating and communicating. And also, there are different system of law and other governance instrumentalities or some commercial practices as distinct in culture. So that is the source of challenge and imposed risks. Perception, that could be perception in some cases, but also may be realized to lead to actual controversy and disputes. And also, one other factor is currency risks. So that's the point. The commercial merchant has to premeditate to his interest. Absent any or insurance kind of a foreign strategies, it might be detrimental, actually avoiding the benefits of a trade. And also, the author illustrates the legal and political risk. So the international community tried every effort to remove or assuage this kind of risk. How to lessen the extent of risk is important. So insurance and other vehicles to guarantee and insure against this scope of risk might be well organized. For example, a lot of credit transactions and many insurance and bank guarantees or so. So UNIDROIT principles actually is a textual authority in principle. And as I've said, it employs the method of the United States, restatement, exact form. And also, other source of law you may have attention in this class is a model law. So you have, for example, model law on arbitration, resolved by the authority of the United Nations, for example. And this approach also operates to remove the difficulties involved in the work of a unification. So the international authority likes to avoid the hard nature of a codification. International agreement is absolutely difficult. So they just agreed on essences of property in the form of model law. So that is not law actually, but could enter into legal force once the domestic authority adopts. That is one kind of important ways identified in the context of a federal system of the United States. For example, the American Bar Association codified a model penal law, which provides a modality incorporated in the modern context of criminal law. So actually, the authority to legislate the Criminal Act is enshrined in each state as a matter of a federal constitution. So the ABA has no authority to adopt the penal law, as you see, but the modality may be received favorably by a state legislature. But actually, that is not the case involving modern penal law. Nonetheless, we have brilliant success in the area of commercial law. You can see UCC, Uniform Commercial Code. And that is the exact illustration to reveal this context of unification of laws. Of course, it is domestic in the dimension And that way was employed by also international community. Now, one point I'd like to advert is the UCC is also a principal source of law we have to study through the course, although it is a domestic commercial code. That means the United States is a major trading country in the global context. So its influence in terms of the practical strengths of the scope, for example, it is culturally, legally leading and also influential. And actually, major players engage in international trade. So it is one source of law subject this class in radio focus. And what is the source of law for this area of law? International trade law is also controversial. For example, model contract is source of law. How extend the scope of customer law may be conceptualized into any definition of this law. That is the question, and still argued. In any case, the controversy also stems from the domestic law. For example, Korean Commercial Code is the class of international trade law. That is a difficult question. Actually, by way of operation of conflict law, Korean Commercial Code may apply to international trade. In that case, we can see limited sense in recognition and may cohesively attribute the kind of a international trade law. And vice versa, we see a controversy about CISG. CISG may be seen by some of the scholars as a domestic law, although it is an international agreement. How do you assess this perception? That is practically true if you see the process that the domestic judges practice over the assigned cases. For example, if they are responsible to deal with the international question in private law, they may refer to forestry. In many cases, not always though, in many cases the conflict of laws provided by Korean legislature. So they may choose the applicable law to the case at bar. Then there should be taken in as international trade law, problematic, but may be true in senses. CISG may be directly applied to the case or in some cases, and typically, the integration of international community is posed, and CISG would be chosen in considerably large scope of transactions by involved parties. So it may be kind of a domestic law, practically applied to the cases, and without any difficult deliberation about a choice of law question. So that is the aspect that we agree on the viewpoint about its nature. CISG may be domestic law in operation, practically. And unilateral principles, as a matter of law in nature raised a difficult threshold issue about the scope of application. So the context was spelled out in the title or preamble, as you see. So, upon what condition the CISG could be applied? That is the starting point. We begin with this document. And later we have chance to explore the scope of a basic principles. So in preamble, you can see purpose of the principles. These principles set forth general rules for international commercial contract, and they shall be applied when the parties have agreed that the contract be governed by them. They may be applied when the parties have agreed that the contract be governed by general principles of law, the lex mercatoria or the like. They may be applied when the parties have not chosen any law to govern the contract. They may be used to interpret or supplement international uniform law instruments. They may be used to interpret or supplement domestic law. They may serve as a model for national and international legislators. So you have some familiar words and declarations, unlike the Korean code books. We may have some definitions about the scope usually across the Korean codes, but the context was providing some of a different nuance and other different guides. And the unilateral principles, as you may see in the twin context, the European contract law includes the basic principles about contract law. And the provisions would not be extensive, but never reduced in comparison with other international codes of agreements. The provisions span virtually the same in quantity with what CIC and later posted. About over 100 provisions were provided to dictate the rules and principles of the international contract. So the scope of, in its definition, spans across types of international agreements. It is not limited to sales contracts like the CISJ, as you see. So the principle may well operate to apply to all scope of the international contract. Then we may subject to the next question, what are international contracts? And also, we also define a commercial contract. What is commercial? This is a two attribute as a threshold matter to think about the scope of this document. And very wisely, the drafters did not intend to define a positive. So one is not offer a direct answer to this question. Rather, they approach by excluding some of non-applicable sphere. So the international character of contract may be defined in a great variety of ways. The solutions adopted in both national and international legislation range from a reference to the place of business or habitual residence of parties in different countries to the adoption of more general criteria, such as contract having significant connections with more than one state, involving a choice between the laws of different states, or affecting the interests of international trade. The principles do not express lay down any of these criteria. The assumption, however, is that the concept of international contract should be given the broadest possible interpretation. So it's ultimate to exclude only those situations where no international element at all is involved, where all the relevant elements of contract in question are counted with one country only. So they first try to define the national nature of contract in the purpose to exclude. So the actual consequence is the scope could be more broadened, best extensively as possible. So that, of course, corroborates with this nature of document, the nature of this document. So it is principle, so many practicalities and in theory could have potential to apply to vast area of a contractual relationship. So it is helpful to see the comment and black letter laws coupled with the provisions. So the actual provisions are reduced to over 100. But the comment and black letter laws, and also illustrations are helpful to understand the dynamism of this document. Very intrigued nature and comprehensive is kind of a domestic, civil or commercial code. Then what are commercial contracts? The restriction to commercial contracts is in no way intended to take over the the distinction traditionally made in some legal systems between civil and commercial parties and or transactions, to make the application of principles dependent on whether the parties have the formal status of a merchants and or transaction is commercial in nature. This sentence also applies to your case. You may have that kind of comprehension between civil and commercial. So the element of merchant or the intent of parties to seek a commercial interest and some other attributes are offered to distinguish between civil and commercial. The document also has some elements in very context, as same as that, but you may have a major difference. The idea is that of excluding from the scope of the principles so-called consumer transactions, which are within the various legal systems, being increasingly subjected to special rules, mostly of a mandatory character aimed at protecting the consumer. Party who enters into contract otherwise than in the course of his trade or profession. So the concept is to define the commercial contract against the consumer contract, consumer one, not civil and commercial. So vast area of the traditional scope about a civil contract would be governed by this document. The only scope not pertinent to this scope of norms, it would be a consumer contract, consumer transactions. So the concept has a subtle difference, and the basic reason to distinguish between consumer contract, consumer transactions, and commercial transactions lies in its major differences that the public policy more readily apply to the consumer transaction, since the public also often has a major responsibility to protect consumers. So many ways of domestic measures may be found in the context of consumer transactions. We reasonably operate to exclude this area of law from this scope of doctrine. So cumbersome task to shape the common feature of public policy, and actually hard to reconcile in a basic force. You may see large scope of the differences in national passion and culture and history, for example, that is absolutely not the same between nation states of Middle East Asia and Korea and other Japan or United States. So, as I've said, the unification of public law is more challenging for the international actors and players. And what is third? The principles and domestic contracts between private persons. Notwithstanding the fact that principles are considered for international commercial contracts, there is nothing to prevent private persons from agreeing to apply the principles to purely domestic contracts. Any such agreement would, however, be subject to the mandatory rules of the domestic law governing the contract. So, that is plainly true as a matter of a legal principle. Freedom of contract dictates in this way, exactly in the force to be applicable, as you see. So, what to agree and how to agree and with whom to agree are basic to understand the freedom of contract. And the intent of a contracting parties are prevailing vastly over any types of domestic or international laws, except for mandatory nature of international public law. For example, in theory, the norms enacted by International Chamber of Commerce would not contradict the agreement between the parties in written expressive language or in implied nature of a contractual meaning. So the intent of parties are absolute. The enforcement of that soft law are actually based on the agreement between the parties. So, with the agreement by the parties, the domestic contract may be governed by the principles, although they are not international in nature. And in what cases are principles applied to the contract, of course, of international nature? The first case would be an express choice by the parties. The parties may agree to apply the principles to their contract. Then it can be applied. The principles represent a system of principles and rules of contract law which are common to existing national legal systems, but best adapted to the special requirements of international commercial transactions. There might be good reasons for the parties to choose them expressly as the rules of law governing the contract. In so doing, the parties may refer to the principles exclusively or in conjunction with a particular domestic law which should apply to issues not covered by the principles. Parties who wish to choose the principles as the rules of law governing the contract are well advised to combine such a choice of law clause with an arbitration agreement. So the drafters saw the arbitration is a more efficient form as a dispute settlement vehicle. That is, of course, related with the nature of this contract in its spacious and quality. More agile and other flexibility in the nature of this norm, and more friendly with arbitration than a court proceedings. Also, you may have the concept, the rules of law, which the contractual law is, in principle, the wage of operation of private law. So the intent was permeated into the state authority was they have agreed. So it is it turned to be transformative into law, although they are agreement in private nature. So the private nature of a contract acquires the force of law by switching into a transgressing over the line between private and public. See? The reason for this is that the freedom of choice of the parties in designating the law governing the contract is traditionally limited to national law. Therefore, the reference by the parties to the parties will normally be considered to be a mere agreement to incorporate them in contract, while the law governing the contract was to have to be determined on the basis of the private international law rules of the forum. As a result, the principles will bind the parties only to the extent that they do not affect the rules of applicable law from which the parties may not derogate. So the context remains the same as in the case above. So the principles could not derogate in nature the public policy of each nation. So it is a sovereign nature operating on the basis of agreement. For example, if they agree apply to the domestic case, the agreement does not annul the clauses of public policy. And the context also extended to the international contract. The situation is different if the parties agree to submit disputes arising from the contract to arbitration. So that is also some of point advisable to patronize the arbitration when the parties choose principles as a governing law. Some of mandatory clause should be focused. Okay. So actually, this room is very big for education. So we have some more points in this preamble dealt with in next class, and we also explore some of first part of principles, first part of this document. A class as a principles. You may have many words familiar through the classes of law department. For example, freedom of contract and the doctrine of equitable treatment, good faith dealings, the kind of concepts often upheld in the civilized civil codes would be in scope under your review. So, okay. So see you in the next class. Thank you for your attention.